We are interrupting your programming today to bring you breaking news. The man accused of murdering 4 University of Idaho students is back in court this morning and is expected to take a deal to plead guilty.
Bryan Kohberger accused of killing Madison Mogen, Kaylee Gonzalez, Ethan Chapin, and Xana Kernodle in their off-campus home on King Road in November of 2022.
He is facing 4 first-degree murder charges as well as a burglary charge.
Under the terms of this agreement, Bryan Kohberger is expected to plead guilty to all 4 murder charges. He will waive his right to appeal. That means he will not have the opportunity to raise any legal complaints or claim a violation of his rights in the future. Kohberger will also agree to spend the rest of his life in prison without the possibility of parole. Latah County prosecutors were seeking the death penalty in this case, as you know. That would no longer be on the table if this plea agreement is accepted by the court, and the trial will be canceled.
Now, some family members of the victims arrived to court just about an hour ago. We're just about 15 minutes away from the hearing starting right now. The Chapin family is there. You can see the Gonzalez family arriving to court right there. Steve Gonzalez, Kaylee's dad, walked toward the courthouse, then walked away, turned around. Right here, you can see him walking back to the courthouse, then talking to reporters. Take a listen.
He needs to protect those other surviving victims and make this person say that they had nothing to do with it. He did it solely, he did it all on his own, and nobody else was responsible. And then we won't keep having these supporters always saying that he got set up. We know what he's planning on doing. Somebody died, a vet died, and he's going to try to say that, put the blame on that person. So he's not going to take accountability.
Now, after news of the plea deal, some of the victims' families released statements sharing how they feel about this. The family of Kaylee Gonzalez posted on social media yesterday saying, quote, "We will not stop fighting for the life that was stolen unjustly," end quote.
They went on to say they're asking for a full confession, full accountability, location of the murder weapon, confirmation that the defendant acted alone, and also the true facts of what happened that night. You heard Stephen Gonzalez talking just there about why he's dissatisfied with this deal.
And by the way, he says he is not going to go in the courtroom this morning. We'll see if that holds true. While Stacey Chapin, the mother of Ethan, told us their family is in Boise today. We did see them walking into the courtroom this morning, and they are in support of this plea deal.
New this morning, a statement from Maddie's father, Ben Mogen, right here, obtained by her sister station in Spokane. He says in part, quote, "The plea deal the prosecution has proposed is one that punishes the perpetrator of this horrendous crime, protects the public from further harm, and allows all of us who knew and loved these 4 young people the time to grieve without the anxiety of the long and gruesome trial, years of appeals, and potential for mistrials all along the way," end quote. Have not heard any comment from Xana Kernodle's family yet.
They have been very private throughout this whole process. There is a lot of media outside the Ada County Courthouse. We showed that to you this morning. Media outlets from all over the world. They've been set up since very early this morning. Andrea Dearden live at the Ada County Courthouse right now. Andrea, tell us what you're seeing there. Set the scene for us.
Absolutely. Well, Maggie, Justin, there are dozens of media outlets here lining up the front of the courthouse, essentially both sides, filling the courthouse, even people stationed across the street in order to get a firsthand look at what is happening inside these doors, inside the courtroom. And as you said, that's expected, that hearing expected to start in about 15 minutes. People are very anxious to hear. Of course, this has been a story that has gotten national attention, international attention, and so media, but also people in the community just being very interested in what is happening. They want to know what will be said today. They are very anxious to hear what Bryan Kohberger will be asked today, how he will answer. This will be one of the first times that we've been able to get any sort of response from the defendant. We know that we're expecting the judge to ask, Judge Stephen Hippler is the presiding judge here, we're expecting him to ask the defendant if he is doing this, if this plea agreement is something he has agreed to voluntarily. He'll also want to make sure that he understands exactly the terms and conditions to which he is agreeing. That is a big piece of a judge accepting the plea agreement. Yesterday, I sat down with Boise attorney Tara Malik to talk about some of the things. We talked about the victims' responses. That is one one element that prosecutors certainly consider when they are looking at whether or not to offer a defendant a plea agreement. But as Tara told us, there are lots of other things to take into consideration as well. This is not something that they take lightly.
So I'm sure that both sides really sat with the information that they had and assessed, what their trial strategies were going to be and what the risks were going to be if they proceeded forward. If there are victims involved, like there are in this case, what the victim's desires are and what their hopes are. And then finally, you're looking at what the reality of the situation is. What's your best case scenario if you go all the way through trial? Do you think that you're going to prevail? If you prevail, what happens after that? Is there a likelihood that there will be appeals? And most importantly, is there a plea arrangement that we can come to and a sentence we can come to where we really think that justice is being served and we're holding someone accountable for wrongdoing?
What we believe will be presented tomorrow at that hearing is guilty on all counts. So in that case, it is the best case scenario. We're not dropping any charges, they aren't amending any charges, but full conviction on all 4 of these. Is that really the best case scenario for prosecutors?
If it's going to be a guilty plea to all 4 counts, to the 4 counts of murder, the 1 count of burglary, and we're talking about life sentences, no possibility of parole, consecutive life sentences, meaning stacked on top of each other, not happening at the same time, that's a good outcome because you are avoiding the uncertainties of trial. You're avoiding the costs of trial potentially.
You talked about the families being consulted or at least taking into consideration what they may want or their desires. Here we have multiple victims, perhaps families likely that feel differently, have different opinions. So how does that weigh on defense attorneys and prosecutors?
Well, they have to be consulted and kept in the loop. They have victims' rights, they have statutory rights there. But ultimately, at the end of the day, the prosecutors don't represent a single family or a single victim, they represent the state. And so they have to do what is in the best interest of all in this scenario.
Judge Hippler is the presiding judge in this case. He will hear this agreement and does play a role, meaning that he has to accept it. But it's a limited role. So what will he be weighing and what does he really have to decide when it comes down to whether or not to accept this plea agreement?
What I anticipate happening tomorrow at tomorrow's hearing, if it is indeed a plea change hearing, is that the judge is going to engage in what's called a plea colloquy with the defendant. And what that means is he's going to make sure that if a plea is indeed being entered, that it's being done knowingly, voluntarily, that the defendant understands the charges against him, understands the plea agreement in its entirety before accepting that he's not being coerced or forced into making that plea. It's going to be even more imperative that the judge really gets to the heart of making sure that this defendant understands the rights that he is waiving.
That is probably the biggest piece of this plea agreement, or the one that caught my eye, is that he will waive, if what we understand to be true, that he would waive all rights to future appeals. How significant is that and how unusual is it?
Well, it's very significant, especially in this type of case where we were looking at potentially a death penalty case. Death penalty cases, as most people are probably aware, there are lengthy appeals. You could be wrapped up in appeals for decades. There are rights, appeal rights that an accused has. And so it's a significant condition, if it indeed is part of this plea arrangement or agreement, that there's a waiver of those rights. That's a lot of time, it's a lot of cost, it's a lot of uncertainty that goes entirely away.
A lot of uncertainty that goes away, and I believe that's exactly what we heard from the Mogen family in their statement about having that certainty of convictions and knowing that they will not have to face likely years, decades even, which is what we see oftentimes in capital cases, and that's exactly what this would have been if it had gone to trial. The prosecutors were seeking the death penalty. So had this been a capital case, we could have expected years and years, again, even decades of appeals, and I think that is certainly one of the things that you heard from the family, saying that that is one of the reasons they support this plea agreement. Now, one of the things to listen for today will be whether or not this is a binding binding agreement or a non-binding agreement. A binding agreement means that the judge, the court, is bound to hold to this agreement, meaning he will have no discretion when it comes to sentencing. He will agree to follow the recommendations, which would be those 4 consecutive life sentences. You heard Tara say, if. We are still waiting to hear it outlined in court today. We have seen those 3 conditions that you, Maggie and Justin, mentioned earlier, the life sentences, the convictions, the guilty pleas, but we don't know yet some of those very specific details. Like, will there be things in there about not speaking publicly about the case? We have had a gag order in place in this case from day one, so that is also one of the conditions that could be in this agreement. So we're going to want to listen closely to see if we hear all of the terms that are outlined.
And Andrea, what's really interesting is we saw Steve Gonzalez walk out in protest. He says he's not going to go into the courtroom. One thing the Gonzalez family said last night is, at bare minimum, please require a full confession, full accountability, location of the murder weapon, confirmation the defendant acted alone, and the true facts of what happened that night. We deserve to know when the beginning of the end was for their daughter, Kaylee. I do understand these answers may not have been given through trial, but that should be the minimum price to pay for his own life. That is what the family is saying right now. What are the chances that something like that is woven into this plea agreement?
Well, I actually talked to Tara Malik specifically about that. She was quick to point out that there is no guarantee of closure in any trial. In fact, there are often times where evidence is presented and may actually cause even more questions or leave people wondering, what it really means. And so I think that idea that there will be closure, that we will get a full confession. Remember, by law, the defendant is not required to say anything. Now, he will have an opportunity during the sentencing hearing. All defendants have the opportunity to address the court, just as the victims' families will have an opportunity to address Kohberger, the defendant, also address the court, talk about, we call that a victim impact statement, talk about the impact that these crimes, these killings have had on them. Those are often very emotional. Certainly that's when we hear from the family and all of the pain and all of the suffering that they have had at the hands of this defendant because of the crimes that he will have admitted to committing. But whether or not we will ever get that full statement, that would be very, very unusual, and we have not had any reason to believe that will be part of this plea agreement that we will hear presented today.
Andrea, thank you. Now, speaking of Steve Gonzalez, we saw him walk toward the courtroom and then walk back out. And as we've talked about, this case has worldwide attention. Can you show us what is going on there outside the courtroom? Is Steve Gonzalez still there? What does the media look like as well?
I'm going to step out of the shot so that our photographer here can pan across the front of the courthouse here so you can see. I can recognize national media outlets, local media outlets from North Idaho area. Also, of course, here in the Treasure Valley, this case moved from Latah County here to Ada County in order for them to have a better chance of finding an impartial jury or having a bigger jury pool to pull from. We don't know how far into that process they had gotten. We do know that surveys or jury summons were issued in Ada County. I saw a lot of conversation online about people who had gotten that summons saying that they were going to be expected to be in court, and a lot of people wondering if that meant that they could potentially be in the pool for the Kohberger case. But we know that isn't going to happen. So if this plea agreement is accepted today, and again, Judge Hippler, really the only discretion he has here, the thing he's going to be weighing is whether or not it is fair, whether or not the defendant is entering it into this agreement willingly, and if he knows exactly what he is agreeing to. Short of that, we would expect him to accept this agreement. Now remember, even if the agreement is set today and it is accepted and that plea is changed, that will happen today, but the sentencing wouldn't happen for a while. Again, we still have the opportunity for those victims to come in and address the court, so we would expect to see a sentencing hearing later on. It could be weeks from now, and as Tara told us yesterday, it could be several months. It's all just about when they get that scheduled.
And Andrea, we also know that the Kohberger family, Bryan Kohberger's family, is going to be in the courtroom as well today. The family did send out a statement. I'm going to read that to you. It says, in light of recent developments, the Kohbergers are asking members of the media for privacy, for respect, and responsible judgment during this time. We will continue to allow the legal process to unfold with respect to all parties and will not release any comments or take any questions. We ask that you respect our wishes during what is a difficult time for everyone affected. So the family recognizing this is a tough day, probably wanting to stay under the radar there. What are your, in terms of seeing Steve Gonsalves? We mentioned he walked out. He said he was going to stay out of the courtroom. Do you happen to see him near the courthouse moving about there?
I haven't seen him here. Of course, we will keep an eye on him. We have, our view is blocked by canopies and tents and cameras and lights and things like that, but we will certainly keep an eye. We do have several crews here. We will be following everything inside the courtroom and also what happens outside of the courtroom after this hearing concludes. We don't expect it to be a super long hearing. Really, it's a procedural hearing, so they would likely go through the agreement, have that plea colloquy, as Tara Malik talked about, having that back and forth with the defendant, those questions and answers that we would expect him to say, yes, he agrees to this, and then the hearing should conclude. Now, they may talk a little bit about scheduling at the end, but we don't expect it to be super long. Of course, we will stay here throughout its entirety. We'll bring it to you streaming live, and we will be here afterwards to talk about what happened and to kind of break down what we know.
And we appreciate that you're going to be there for us to help us do that, because you know all the legalese of what's going on.
Yeah, Andrea, that really invaluable insight there. Really appreciate it. And again, we were talking about the victims' families, them there, and the fact that the Mogen and Chapin families were in support of this plea deal, the Gonsalves family, because they just wanted to know what happened that night. They very much seem to be not in support of that plea deal.
Yeah, well, Steve Gonsalves has been very vocal from the get-go. Andrea knows this from the day this happened, that he wants this person found and he wants the death penalty for this person. Obviously, the trial's not going to happen now if this all goes through today. And the family spoke with the prosecution on Friday, from what we're understanding, about the idea of a plea deal, and they said they were firmly against it. They told the prosecution that. They say by Sunday, they received an email that sent them scrambling, in quotes. And they met with the prosecution again on Monday of this week to explain their views about pushing for the death penalty. But as you all know, the plea agreement was made, and we'll see if it all moves forward as of today.
And a quick update, as you might have seen right now, it is 11:02, a couple minutes past when this hearing, we were expecting it to start, but we imagine there's a lot going on behind the scenes to get their ducks in a row right now.
Yeah, and Tara Malik, the attorney, told Andrea, and Andrea, we can bring you back in here, that really they don't have to do anything for a specific family. What they're trying to do here, the state, is do what's best for everyone involved here. And obviously, the Gonsalves family, very passionate. They have their views about what they want to see done here. And the other families may have a different view. So tell me how that all weighs in when they're considering something like a plea deal.
Right, well, the bottom line is, remember what Tara reminded us, and that is that the prosecution represents the state. They are not representatives of any one individual victim or any of the victims' families. They do, as victims, have rights, and so they do need to be consulted. They need to be kept involved in the process. In other words, they need to be informed when something's happening. They have a right to know when there is a hearing, regardless of what that hearing is about. But there isn't anything in statute or in ethical standards that say the victims need to vote or get to weigh in, or that they have to approve a deal or prove an agreement or any action taken by prosecution. And so that is a difficult thing. Of course, this doesn't mean that any of these feelings by any of these families are anything short of valid. You can only begin to imagine what they're experiencing and what they have experienced since that night in November of 2022. So, for us to put ourselves in that position and know what's going on in their heads and in their hearts, I wouldn't begin to do that. However, you can see here why, people grieve differently, people process differently, people have different ideas of what justice is, and it's clear here that we have at least two of the families who are saying, for them, this does bring about a sense of peace or a little bit of relief. They were not looking forward, it sounds like based on their statement, not looking forward to those weeks, months of trial. I mean, think about all of the evidence that would be presented, that they would be sitting through and listening to. We know we just went through the Vallow-Daybell trials. We know we saw that evidence, and we heard from those families of victims how they were impacted by that and how difficult that is and what a toll that takes on them. So you can certainly understand that feeling from those families who say, I prefer not to do that. Remember, we also have a roommate who survived this, who was in the house at the time of the attack, likely Dylan being called to testify. That also would be a very difficult position to be in. So these families are saying, the two families we've heard from that say, yes, I support the plea agreement, that's what we're hearing them say. Now, on the other side of that, certainly also just as valid. If the Gonzalez family says for them, justice is the death penalty, justice is being able to know exactly what happened and maybe even why, they're not getting that in this case. And so for them to be upset and for them to feel like they haven't gotten enough from the court makes a lot of sense as well. The problem is that all four of those families are represented or are, a part of the exact same process. So having two very different opinions, what plays out in court is going to affect them differently as well.
Absolutely, Andrea. As you talked about, we had heard from members of the community who said, I just want what the families want, but here we have a situation where the families are disagreeing on what they want. But as you said, the prosecutors are trying to represent all of them.
Yeah.
And
that's
also,
so tough.
Also the community, the state, the public. Getting back to the terms of this agreement, sure. Kohberger would plead guilty to all 4 murder charges, waive his right to appeal. So that means that these families would not have to come back, potentially relive this waking nightmare that they've been in the past few years and give more statements during those appeals. Also, this would be life sentences without parole, so they would not be brought back for those parole hearings either. This would be something where, as best they could, and again, as Andrea said, we can only start to imagine what they're going through, but can move sort of to the next stage in the healing process, the grieving process, to not have to deal with this on a judicial level going forward.
Absolutely. And Andrea, the death penalty, as we all know, I mean, there are years of appeals. It could be 30, 40, 50 years before he would be executed. And the parents of these children, of these young people, would not live to see him executed, most likely, with the appeals process and what happens with the death penalty. Am I right?
Absolutely, and you're also assuming a conviction and assuming that the death penalty would be ruled upon, it, that the jury would agree that the death penalty was the right sentence. And we know that that also is not a guarantee. We have had dozens of defendants in Idaho over the last few decades eligible for the death penalty, but only a handful actually sentenced to death. And so again, some of those assumptions or some of those beliefs are, as Tara said multiple times, a lot of ifs. So trial is inherently risky. There are no guarantees, and I think that's really what they're trying to balance. The prosecutors are trying to balance justice. They're trying to balance victims' opinions, victims' desires, victims' wants, with also making sure that there is some accountability, enough accountability for there to feel like there is justice in this case. Now remember, defense attorneys also have to weigh this out because it is their job to represent Bryan Kohberger and do that to the best of their ability, give him, all of the rights afforded to him through our judicial process. And so they too are weighing this out. What are the risks of going to trial? What are the chances that they would be able to get an acquittal for Bryan Kohberger? Is that risk worth not taking a plea agreement because they are clearly agreeing that their client is guilty and will go to or agreeing to say that he is guilty and allow him to go to prison for the rest of his natural life. So everybody kind of weighing that out, and it is really just a really large balancing act and a whole lot at stake.
Really, it is. And I think I want to bring the focus back at 11:08. We are still waiting for court to begin. It was set to begin at 11 o'clock this morning. We'll cut right to the courtroom when it starts. But I think we really want to focus on these 4 beautiful young people, these college students who we have all come to know so well over the past few years. Autopsies show that these 4 victims were all likely asleep, which just shows the heinous situation and the terrible crime that this was when they were attacked. Some had defensive wounds and each was stabbed multiple times. And online shopping records show that Kohberger months earlier had purchased a military-style knife and a sheath like the one found at the scene. That's according to court documents. Now, it's also important to note at the time of the killings here, Kohberger was a criminal justice graduate student at Washington State University. That is 9 miles west of the University of Idaho, for those of you who don't know the region very well. He was arrested in Pennsylvania, though, when he went home after the killings, about 9 miles west of the university, where his parents lived, that is, weeks later. Investigators say they matched his DNA to genetic material recovered from a knife sheath found at the crime scene as well. That is what they're claiming, and there has been a lot of controversy over that genetic genealogy. Andrea, they brought that up in court quite a bit, and that may be one of those factors that they talked about that could maybe lead to not getting a conviction. The genealogy, there's been complaints about Dateline episodes. Talk to us a bit about some of the things that were risky.
Yeah, absolutely. That was one of them. That was something that the Kohberger defense team has spent hours arguing in court against being able to use some of that genealogy. They also argued things like, was it legal for investigators to pull data and pull information and pull DNA from the trash at his parents' home, at Kohberger's parents' home, things like that without a search warrant. And so, all of those things that we have learned through these hearings, we know very limited information about all of the evidence. We do, through those hearings, have heard that there was mountains of discovery. In fact, you heard defense attorneys ask for a delay because they were having trouble getting through all of the evidence that they needed to consider and they needed to review and essentially strategize their response to. And so we do know that there was lots of evidence that we expected to be presented in trial, even though we don't know what all of that is. And quite honestly, as we've said before, we may not ever know what all of the evidence was. But that genealogy DNA, a lot of new science coming out. There's a lot of information out in several cases across the country that have relied on this genealogy data. I know that, in past, the law enforcement was able to look at about 20 different markers in a person's blood and make those matches, which would only match you to maybe 1 degree of separation, so to an immediate family member. Now I know that they have thousands of markers and can easily identify someone 4 to 5 to 6 people away in your tree. So we're talking about fifth cousins, sixth cousins. Certainly most of us couldn't even name our 5th or 6th cousin, but yet this DNA genealogy is able to identify it. Most of us haven't even met them. And so this new DNA that they are using, this new DNA examination, this type of lab work that they are doing now is impressive, but it also, also certainly draws into question some ethical considerations and some questions about how reliable is it, and is it enough? Is there enough certainty in that data to be able to get a conviction in court? And I think we're going to see these kinds of arguments played out in courts across the country for some time. And the evidence, the science is simply going to get better and better. And so these are questions that are probably going to weigh heavy on courts, because it's going to be a really important process in a lot of these criminal investigations.
Andrea, again, appreciate that. If you're looking at the clock now, it is 11:13. So hearing was scheduled to start 13 minutes ago. We have heard they've started bringing the media in, so we are getting closer to that hearing actually started. And again, trying to focus on the victims here as much as we can. 4 wonderful young people there at the University of Idaho, their lives really just starting. Madison Mogen, Kaylee Gonsalves, Ethan Chapin, Xana Kernodle. Maggie, you talked about sort of the heinous nature of the crimes, the multiple stabbings, and that's why the Latah County prosecutors initially seeking the death penalty in that case. That would be off the table if this plea deal is accepted. And again, speaking of the heinous nature of these crimes, as you talked about, Maggie, it was weeks before they caught and arrested who police and prosecutors say is the person who did this. Weeks that community of Moscow, Idaho, even really the whole state was wondering, where is this person or people that had stabbed to death 4 young people at the University of Idaho? It was a tenuous, flat out scary time.
It was.
For a lot of people in the state.
It really was. And it looks like that hearing is about to begin. So let's go to the courtroom right now.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly, and so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal's Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right, that said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically the only thing the court could do would be a lesser sentence at sentencing. but the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed, substantive questions, let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count 3, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line from Moscow that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents. The defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defendant's car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. The defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor, it was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, this Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you, Your Honor.
Thank you. All right, based on the state's proffer and importantly based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. Court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. Right. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date, because of what I'm sure will be the significant interest of the media and the public, and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through sentencing.
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn, in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor, thank you.
I assume that the trial date will be vacated and those 4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Have it, Bryan Kohberger pleading guilty, and that plea deal accepted by Judge Hippler. They're guilty on all 5 counts, 10 years fixed for burglary, and then, of course, life fixed, consecutive sentences, life in prison on 4 first-degree murder charges.
And the judge asked Kohberger each count, talked about each victim, named them, asked him if he was guilty of killing them. Take a listen.
So as to count 1 burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count 2, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count 3, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
There you have it. Bryan Kohberger again admitting verbally in court that he killed Madison Mogen, Kaylee Gonzalez, Ethan Chapin, Xana Kernodle.
And our Andrea Dearden is live at the Ada County Courthouse. They are filing out of the courtroom right now. Family first, then of course the media and any witnesses. And Andrea, we may just hear from some of those family members, or can we? Because the judge is keeping the gag order in place through sentencing, which we know is now scheduled for July 23rd.
He is, but we did just see Kayla Gonzalez's father come in just now. We've talked about how he did not choose to be inside the courtroom. In fact, he walked out of the courtroom earlier today, as we talked about before the hearing. Here he's meeting other family members as they come out following the hearing. So we will see if anyone is willing to give a statement. Of course, obviously they have issued statements on social media and offered their family's thoughts. Of course, you heard the Gonzalez family say they are outraged. They do not believe justice was served in this case. It does not appear that they are going to come and address media directly here. So we do have an area set up here for families to speak if they would like to. We will wait for the other folks to come out of the courtroom. This was their opportunity. You heard the hearing there, the Bryan Kohberger pleading guilty to all counts, going through each one of those. And at the very end, the prosecutor getting a little emotional as he read the names of those victims. Certainly a testament to just how heavy this is weighing on everyone involved.
And Andrea, as we wait for family members to come out and possibly comment, let's go right to the beginning of this hearing where the judge started out asking for no outbursts in the courtroom. And I think the courtroom was very well behaved. There were no outbursts in the courtroom. And then he talked about something interesting that I wanted to talk to you about. He said there were calls to contact him and try and sway his decision about this plea. He says he has been dealing with that. It's been very disruptive to the court and to what's going on there. Tell us what you know about that.
I know he did talk about that in the court, to talk about, the calls and essentially the pleas to him in order to change his opinion, or to sway his opinion, is how he put it. And he said that, he wanted people to understand that he has very limited discretion here. So it is his job, just as we talked about prior to the hearing, it's his job to make sure that the defendant is entering this plea agreement willingly, that he understands the terms, and that he is saying and he is admitting that he committed these crimes, and that he is not pleading guilty because of any coercion or because of any threats that he might have gotten. And also to recognize that while this is, we talked about a binding agreement or a non-binding agreement, he is not bound by this sentence. So that means that the judge will go into the sentencing, he will take in all of the information into account, and then he will determine that sentence. We expect him to follow the plea agreement, those life sentences, consecutive life sentences. Also, he will issue restitution, fees, things like that. But what this means, though, is that that's the only discretion he has. So he wanted to make it clear. He wanted to put it on the record that no matter what anyone says when they call, in fact, he said he didn't listen to the messages. He passed on any type of threat or any kind of, problematic message. He said he passed those on to law enforcement. But otherwise, he did not take into consideration any of those comments that were sent here either by phone or by email, because he said that's not his job. His job, his duty, his responsibility is to the court and to make sure that the legal process is followed as is required. But his own opinion, or the opinions of those who have tried to sway that opinion, he said simply don't play a role here. They don't have a place in this process.
Andrea, can I ask you about the demeanor of Bryan Kohberger? This is a man who is admitting to 4 grisly murders. You said everyone was really affected by this. He didn't seem to be affected at all, though, by it.
I can only see what I saw, what you're seeing. I'm paying attention to his body language, paying attention to his voice. I would agree that he seemed calm. He spoke clearly. He spoke loudly enough. It wasn't a meek or mild response to the judge when asked. In the very beginning, he stood to address the court, as you do, out of respect for the judge. Judge Hippler saying you don't have to stand. You can sit while we have this conversation. But yes, I agree that I thought that he seemed calm. I thought that he seemed composed and essentially pretty comfortable in that space, answering those questions as they were asked by the judge. And of course, we all know that those are significant. And of course, also in there, laying out some of the evidence. Most of the evidence that they talked about in the court today was those were pieces of information that we have known as we followed this story. So I don't think there was anything that was super surprising or super that caught us off guard. But it's still difficult to sit there and listen to it. Surely the family, the victims' families can't be easy to hear that. And I wonder if that gives them any solace in having that laid out in the courtroom of exactly what he did. Of course, that not coming from Kohberger himself, but from the prosecutor in this case, detailing the pieces of evidence and the pieces of information that they planned, and some of those that they planned to present at trial. And we've heard, especially from the Gonsalves family, saying they want there to be full accountability, and they want to know exactly what happened, and they want that absolutely shared in court. And I believe they want to hear that from Kohberger himself. That didn't happen. Now, we do know that sentencing will come up on July 23rd, and the defense team and the defendant himself will have the opportunity. He has a right to address the court, but to be clear, he is not obligated to say anything at all. And so whether or not he will have a statement prepared, that will remain to be seen, and we'll have to wait to see what happens during the sentencing hearing, July 23rd.
What's going to be especially emotional and impactful on that day, as the judge mentioned, is that every family member that wants to, who has been impacted by this case, will have a chance to speak. Now, it looks like there aren't a lot of family members coming out right now that want to share at this time. That could be because the gag order is still in place until the sentencing, which is July 23rd, as Andrea mentioned. It doesn't look like anyone's coming up to the microphones to speak, but it's going to be very powerful, very emotional. We're going to hear from probably just about everyone involved in this case. Coming up on July 23rd, they'll have time to get those victim impact statements put together. And as Andrea mentioned, Bryan Kohberger has a chance to speak as well. We'll see if he takes that opportunity or not.
Again, that will be July 23rd, really the next step in all this. And the point of this hearing, as we talked about, as Andrea certainly talked about, was for the judge to make sure that Bryan Kohberger understood that this plea deal, that he was pleading guilty to these grisly murders, that this plea was being given freely, voluntarily, and without coercion. And again, he confirmed all that. The only words that he said in court today were yes, no, and guilty a number of times as he was answering the judge's questions. And Judge Hippler there decided that, yes, Kohberger understood the charges against him, what he was agreeing to, and so now he is guilty and facing those consecutive life sentences.
Yes. All right, Andrea, thank you so much for your input, for your coverage today. We have a lot more coming up throughout the day here on Channel 7, but once again, this is over. Bryan Kohberger has pleaded guilty to killing those 4 University of Idaho college students. He says he, yes, is the one who did it. We have more on our website right now, ktvb.com. You can watch what you missed on KTVB Plus. You can also, it looks like we might have some people coming out that might want to speak. So I think we're going to continue our coverage. Maybe it just took them a while to come on out and make that decision.
There are some people congregating there. We'll wait to see if we can hear from them. As you said, as the judge said, the gag order is in place until sentencing on July 23rd. Looks like we have not seen all of the family members yet. We saw Steve Gonzalez at the front of the courtroom and then walking away from the courtroom. He was not inside at the time, had done sort of a protest by not going inside. He was not happy with this plea deal, though according to the judge and the prosecutor will be given an opportunity to give a statement during sentencing.
The family obviously very furious, the Gonzalez family. We did hear from Steve Gonzalez, Kaylee Gonzalez's dad, before the hearing. Let's go ahead and let you listen in on what he had to say.
Surviving victims and make this person say that they had nothing to do with it. He did it solely, he did it all on his own, and nobody else was responsible. And then we won't keep having these supporters always saying that he got set up. We know what he's planning on doing. Somebody died, a vet died, and he's going to try to say that, put the blame on that person. So he's not going to take accountability.
All right, so there's that soundbite there. He was not in the courtroom for the plea agreement. He did join his wife, Christy Gonzalez, afterward there on the steps of the courthouse, and then they left, and with no comment, as far as we know. He could have spoken to some photographers on the way out. We're not quite sure yet, but we are waiting. There's a little stand there with a bunch of microphones from different networks and organizations here of the media who would like to hear from some people involved in the case. If they so choose, we'll see if they do come out.
Now, again, let's go back to this plea deal and what was agreed to, what Bryan Kohberger pled guilty to today. Again, 5 counts, 10 years fixed for burglary, but also consecutive, not concurrent, those would be served at the same time, consecutive life sentences, 4 life sentences each for first-degree murder. He cannot appeal, cannot ask for a different sentence as well. And lawyers said that they gave Kohberger all the information he needed to agree to this plea deal. Again, we heard from him numerous times during that hearing that he understood it, that he agreed to it. While he did not show emotion, Judge Hippler believed that he absolutely understands what he is agreeing to and the seriousness of this sentence and these crimes.
The judge asked him over and over again.
Yeah.
Over and over again, gave him the opportunity to say he did not commit these crimes, that he does not want to take this plea deal. He did not do that. I do want to mention as well, there was a lot of talk about why this hearing happened so quickly. Many family members were concerned. They didn't have enough time to get to Boise to be here for this hearing if they were living out of state or if they were further away. Well, the judge kind of explained that, and I thought that was necessary. He apologized to the family, said, you know, I just found out about this on Monday. So the judge just found out about the plea agreement on Monday of this week, the same day we all did. That's when the judge found out about it. He said, then they met, they talked about it, and he realized they had to get moving on this hearing right away because I guess they're going to call, or they were going to call, 10,000 prospective jurors for this trial. And that process was already in motion. So they had to fix that and put a hold on that as soon as possible if this trial was not going to happen. And as you just saw, the trial has been canceled. There will be no trial, no death penalty. Bryan Kohberger will spend the rest of his life in prison.
Judge Hippler talked about the fact that they had pretty much cleared the schedule, cleared the docket for any and all other trials that could happen that week, that they were going to go through that whole process. Instead, they're going to use the courtroom instead for the sentencing coming up again July 23rd, starting in the morning. I'd like to ask Andrea Dearden another question here. We talked about sort of the sentences attached to each of these crimes, these charges, fixed 10 years for burglary and then fixed consecutive life sentences for those first-degree murders. But clear up, the judge doesn't necessarily have to agree to that. Is that correct, Andrea?
Correct. What he said was he wanted to make it clear that he is not bound by this agreement. And what that means is that he is not obligated by law to follow it. However, he also said as part of the agreement, it's called a non-binding agreement. So think of it legally as such kind of a suggestion, knowing that both prosecutors and defense attorneys are presenting to the court that they have come to this together, that they both agree that this is what should happen and they are expecting to happen at that sentencing. He did make it clear that they cannot argue against this sentence, meaning that they cannot argue in favor of a lower sentence. So we would expect him to issue those life sentences, again, consecutive. That means one after the other. So these are not concurrent. The judge would have the choice to do that, concurrent or consecutive. He said those will be consecutive. But what the judge will also be able to do is talk about restitution, money that would be expected to be paid by Kohberger. Both, there will be two options. There will be restitution to victims, but there's also a civil claim. So he said that up to $5,000 per family that would be paid in civil damages by the defendant to those families. So those are some of the specifics that have not yet been decided that we would expect to see handed down during that sentencing hearing in just a few weeks. And so as you talked about that scheduling and giving the opportunity for those families to get here, he wants to make sure that everyone that is impacted directly by this crime, by law, they have the right to address the court and to be in the courtroom and to address the defendant directly. So today, the Gonsalves family, Steve Gonsalves, Kaylee's father, deciding not to go into the courtroom. So we'll see if he's here and what that statement will be, of course, during that sentencing hearing. We expect it to last much of the day. They talked about probably not needing more than a day, but we would expect to see lots of testimony. And then the defense also has the opportunity to address the court. In a lot of cases, the defense does not issue any kind of argument, don't present anything during that sentencing phase, and the defendant himself may or may not speak. It is very common practice for the defendant not to say anything during the sentencing hearing. Also important to note that this will be the opportunity for people to hear for the first time because of that gag order. This will be the first time that we will hear from a lot of these families, from their own words as they sit on that witness stand and share their testimony. So it will certainly be a very compelling day in court, without a doubt.
It will be a very emotional day, Andrea. Let's talk about the gag order. The judge did decide that he wanted to keep that in place through sentencing, which, as you mentioned, July 23rd, 9 a.m. there at the Ada County Courthouse. What does the gag order mean? Who does it wrap around, and who is impacted by it? Who can and who can't speak? Because as you mentioned, families speak quite a bit on social media, or they'll send us a statement. So who does this impact?
He talked about the non-dissemination order, which would mean that the records will stay sealed. So that means that when we put in public information requests, media often, we have a right to know, the public has a right to know and has a right to documents unless they are sealed by the court. Those are only temporary seals, meaning that they believe that it is too much of a risk to allow those documents to be disseminated, to be shared publicly because of the impact that they may have on a potential trial. Given that this is such a high-profile case, they are going to wait until after sentencing. The judge saying today that he is going to hold that dissemination order in place until after that sentencing hearing. And at that point, we should be able to get all of the documents related to this case that are a matter of public record. And so Judge Hippler, saying that today that he expected those requests to be voluminous. He knows that a lot of people will be putting in requests for all of that information. Now, in terms of what people can share, so non-dissemination means you can't share information directly related to the case. That doesn't mean you can't have your own opinions and you can't have reactions to things. That is not what the law protects. And so in this case, it means they can't share evidence, they can't share documents, they can't share video related to the case, but they would be able to speak about their opinion. Now, whether or not they feel comfortable doing that, that's up to them. That's up to their own discretion.
Andrea, thank you for that clarification. So we are staying live right now in case there are some families who come out of the courtroom and want to share their opinions. Again, not evidence, anything like that, but just opinions, reaction to what they heard and what they saw today in court. We'll stick around. Perchance that might happen again. Steve Gonsalves has already walked away from the courtroom. He will not be sharing any more this morning.
We will see, though, if he'll provide a victim impact statement where he can speak directly to Bryan Kohberger. That may be something that he wants to do. So we'll see if he does that on Sentencing Day, July 23rd. We do want to get to this because Abby Wilt has been in Moscow for the last few days talking to people there in the community, getting their opinions about how they feel about the plea deal. Right now, she's live right outside where the King Road house used to stand. It was torn down in December of 2023. Abby, show us the scene there. I know there are still teddy bears and flowers and letters left for the victims there.
Maggie, Justin, it's clear here that people are still really in grief. You can see behind me where that house sat. It was 1122 King Road. And you can see there those teddy bears, flowers, just a lot of signs of people still healing here at King Road. And like you said, there was a house here that is where those murders happened. Again, that has been demolished since. And I've been talking with a lot of people here in Moscow the last couple of days, just asking them how they feel about this plea deal, if they wanted it to go to trial, if they wanted to see Kohberger face the death penalty. And again, like you said, people have very mixed reactions. I think it's very clear people here just want healing. They're tired of their town being in the spotlight. They're tired of having so much attention on them time after time again. And a lot of them said that they do just want closure. We've been trying to talk to some of the neighbors around here. That house right beside me, you can see that one was the one that had the surveillance footage of Kohberger's car leaving that was revealed a couple of months ago. Like I said, people just are very willing to see closure come to this case. They're ready to have closure. And a lot of these neighbors, I want to point out too, might not be the same tenants. This is a college town. We're right next to the University of Idaho. All of these homes are mostly college students. So the people that did live here when those murders happened, again, might not be living here now, but just the town in general, the sense of the town in general, is they want closure. They want to have healing. And whether that came in the form of this plea deal or that came in the form of the trial through the death penalty, it's very clear that healing is kind of what's on everyone's mind as well as justice. And like you said, that gag order has not been lifted. We thought that maybe it was going to be lifted today. It will not be lifted. So some of those people here in Moscow that haven't been able to speak up yet still will not be able to talk today. But we're going to be trying to gather more reaction today from city leaders, from University of Idaho leaders, and just from the community in general on what this means to them.
And Abby, we know you did talk to several people out there in the community. We shared some of that this morning.
Mm-hmm. Yeah, let's hear what they had to say actually right now.
I believe scriptural mandates are that when you take a life, you lose a life. And I think if anything less than that, I'm not real satisfied.
In my opinion, if you get life in prison, it is the same as the death penalty. I know it doesn't give people that same sense of justice knowing that they were taken off the earth. But to me, if they have to spend every waking hour in prison instead of being out in this world, that's the death penalty either way.
It would have been cathartic to see him dragged into court and to have all the evidence of the case scrutinized again.
I think it'll be really good for this whole trial to wrap up. I feel like every time there's an update in the trial, this town gets more, it reminds them back to when it happened. So I feel like it gets more and more stressful for the community.
It also would have continued to keep the spotlight on a community that maybe doesn't want the spotlight on them anymore. Maybe it's time for there to be true healing, to know that there's been resolution.
No, I think life in prison is better than the death penalty. I think that kind of gives you an out. You don't have to suffer as much, not really suffering, but I think he deserves to rot in prison.
Well, I think we'll appreciate the closure, but justice is part of that. And if we don't have justice, I'm not sure that's closure. And he took 4 lives, innocent lives. I think he should pay with his.
So none of us can
Maggie
really.
Justin, that was a mix of University of Idaho students. That was a mix of Moscow leaders. Sorry, I think I cut you off there, but that was really just a mix of a lot of people here in Moscow, of leaders, of students, of people that were here during the time of the murders, of people who came to University of Idaho after those murders happened. So it really is just a general sentiment of people are confused and they want healing here.
Want healing, want to start to move on. We're hoping potentially the families can get that as well. But we've already heard from some family members who say this is not that justice they were looking for, and so that healing not necessarily beginning for them.
That's true. All right. Thank you so much, Abby. We appreciate you joining us there live from Moscow. We do want to mention we've spoken a lot about the Gonzalez family and how they feel about this. They are furious. They wanted the death penalty. They wanted a trial. That is what they were focused on, and that did not happen for them today. We also learned they had some conditions. So if there was going to be a plea agreement, they said, you know what? We want some conditions to come along with that. That was requiring a full confession, full accountability, location of the murder weapon, confirmation that he acted alone, and the true facts of what happened that night. That did not happen either. That's not to say Bryan Kohberger may not decide to speak at the hearing and share more about the case. Today, he just said yes, no, and guilty. But he made it clear, the judge made it clear, he made it clear that he is the person responsible for these murders.
We had also heard from the Mogan and Chapin families who said they were in favor of this plea deal. Again, they believed that this would help them start that healing process, potentially move on. Again, appeals off the table. Anything like that, potentially just more courtroom appearances for them, having to see Kohberger again and again, talk about this again and again, reliving this would be off the table for them, and that was enough for them in this plea deal. We had not heard from the Kernodle family, expecting to get that potentially July 23rd on the day of sentencing, but that's how the families are reacting.
Yeah, we might hear from them sooner. They have been very quiet and private throughout this case. Let's get to Andrea. And Andrea, really the reason why this plea agreement is something that they are accepting is because it ensures that Kohberger is now convicted. He'll spend the rest of his life in prison. He will not be able to put the families through the uncertainty of decades of post-conviction appeals. It will effectively be over. Isn't that right?
Right. Absolutely. This is, once that sentencing is handed down based on this plea agreement and his agreement that he will waive all rights to the appeals, then that means it will end. And so he would be moved into a prison, and that's where he would stay for the rest of his natural life because those sentences are consecutive and he has no right. And you heard the judge go through and ask him specifically, do you feel that you have been represented well? Do you feel that your defense attorneys have given you adequate counsel? The reason he's asking those are the things that appeals are usually based on. Incompetent counsel, incompetent representation, inadequate representation. Those are the arguments that defendants make in court to try to get a new trial or to get their sentence reviewed, their sentence reduced, things like that. Those are the arguments that we most often hear. And so I talked to Boise Attorney Terry Malik yesterday specifically about that, about waiving that right to the appeal. Is there a possibility that Kohberger could later come back and say, well, I took that plea agreement because my counsel did not advise me well or because they were incompetent. And by putting that on the record today in court, Judge Hippler is taking away that option, because what would happen is that he could still make the claim, he could still file the motion in court, but most likely what would happen is that we would see the court go back to today's hearing, go back to the arguments made by Kohberger himself or those answers given by Kohberger himself and say, we're going to dismiss that claim because you've already told us on the record that that's not the case, that your counsel was adequate, that you don't have any reason to believe that they have represented you poorly. And so even if that motion got filed, it would simply be dismissed by the court. And that is what we would expect to see. He can still make a motion, but that would have no validity, and we would likely never see it go to a hearing or never see it go before a judge at all other than to be dismissed. So that essentially ends it on that sentencing date, and as those families said, allows them to then start to heal and start to kind of process and a bit of a relief knowing that they do not have those weeks or months of trial ahead of them.
Thank you for that.
Well, we do want to reiterate that Bryan Kohberger has pleaded guilty to these murders. The judge asked him very specifically several times if he's guilty, if he committed these murders, if he is the one, if he is comfortable with this plea. He said yes to all of those questions, and he also said guilty. He said no to some questions that impacted him as well that didn't have anything to do with this plea agreement exactly. But we want to take a look at that one more time so that you can hear from his mouth what he said about the killings.
With respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonsalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
So guilty to all counts, 4 counts of first-degree murder, 4 consecutive life sentences. That means back to back. He will never be released from prison.
We'll continue to have more reaction and analysis to this plea deal. And again, Bryan Kohberger officially pleading guilty to all 5 of those counts. First-degree murder, 4 counts of that, and also burglary. To watch more, download KTVB Plus right on your TV. You can watch that for free.